Welcome to the Legal A Lot Lat, folks. Today's case, State of Wisconsin versus Andrew Suttenberg. And right out of the gate, we've got a waiver of preliminary hearing. But don't let the calm tone fool youth ones about to heat up.
We will go on the record in the matter 24 CF 252, State of Wisconsin versus Andrew Sonnenberg. The state appears through District Attorney Kevin Schmidt in person. Mr. Sonnenberg appears in person in custody with counsel Glenn Keene. We're set today in this matter for a preliminary hearing and a bond modification request. I have been informed that this is a waiver of a preliminary hearing. Is that correct, Mr. Keene?
Yes, Your Honor.
And we are in victim.
Waiving a preliminary hearing. That's a strategic gamble. Preliminary hearing. Why give up the chance to challenge the state's evidence early? Well, sometimes it's a move to fast-track negotiations or avoid giving prosecutors a preview of your defense. Risky, but calculate.
Compliance victim witness coordinator just walked into the courtroom. Mr. Sonnenberg, your counsel advises that you wish to waive the right to a preliminary hearing. Is that correct?
Yes, Your Honor.
And he fully explained to you what it means to have a preliminary hearing. Is that correct?
Yes, Your Honor.
The burden is on the state to prove a felony was probably committed, and it was probably committed by you. Do you understand that?
Yes, Your Honor.
And do you understand that by waiving your right to a preliminary hearing, that means that you understand and you agree that the state can at least meet that burden? Do you understand that?
Yes, Your Honor.
You understand that at a preliminary hearing, your attorney would have the ability to ask questions of the state's witnesses, to call witnesses to testify for you. He would also have the ability to present evidence on your behalf or possibly discover things about the case, which could include defenses. But for today's purposes only, and for this hearing only, you'd be giving up those rights. Do you understand that?
Yes, Your Honor.
And you understand that for this hearing only, that if the state would not meet its burden as to the felony, I could reduce it to a misdemeanor or dismiss it altogether. But you would be giving up that right today?
Yes, Your Honor.
Do you understand that?
With the waiver out of formal charges away, it's time for the main event. Formal charges and a not guilty plea. The defense is keeping their cards closed, aiming for a speedy trial. Buckle up.
As a result of waiving your right to a preliminary hearing, that means that this matter will be bound over to future proceedings, which could include a trial. Do you understand that?
Yes, Your Honor.
You also understand that once you give up the right, it is forever and you cannot get it back.
Yes, Your Honor.
Has anyone made any threats or any promises to you other than any offer presented by the state for you to waive your right to have a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently. That means you're telling the court that you fully understand what you're doing here today.
Yes, Your Honor.
And voluntarily.
Yes, Your Honor.
As you're, I don't need to go there, sorry. I will find that you're competent to freely, intelligently, and voluntarily waiving your right to a preliminary hearing.
Now, we hit the heart of today's tension bond modification. Bond modification defense is about to argue that this defendant who's recovering from gunshot wounds is not a flight risk. But will that cast sway the court?
Find probable cause and find the matter over. Information, Mr. Schmidt.
I filed the information. It mirrors the complaint.
Would you like to proceed with an arraignment today or set for another date, Mr. Keene?
I'd like to proceed now, Your Honor.
He understands those charges and the maximum penalties.
Yes, Your Honor, and he would plead not guilty.
And he waives former reading, pleads not guilty. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. I don't have an address right now. I believe you said that you have a relative in either Sandstone or Hinckley, or that's where you would be going?
No.
Oh, I thought that's what you had said.
In Maple Plain, my dad.
Maple Plain,
In Round
your
Lake,
dad.
my sisters.
Do you know that address?
I
Because we don't have any address on file for you.
don't know the address of Maple Plain because he just moved from Round Lake to Maple Plain and to a new house.
I was just curious to try and update the file for just for purposes. I have a motion filed by your counsel requesting the court to consider modifying bond. Mr. Keene,
Pitch reduced bond only if a treatment facility confirms treatment admission. It's not just a plea for leniency. It's a carefully constructed trapdoor. If Sonnenberg walks out of rehab, He walks back into jail. Clever move or legal minefield?
I will now allow you to argue those facts on the record.
Thank you, Your Honor. As you know, when you look at bond, some of the conditions are protection of the community and to ensure appearances. I would note that Mr. Sonnenberg, even if you believe you're dangerous to me on a regular basis, note that he currently is a dominant hand, is in a cast, and he's recovering from multiple gunshot wounds. I would note that the last, because he had been in custody in the federal system for a long time, but the most recent case we can deal with in Sawyer in this county, 24 CM 49, he did make 3 or 4 appearances. The one he didn't appear at was excused after input from his attorney. I don't know what the circumstances were. And
Circumstances where the court wanted to just get the matter resolved and heard from, I believe his attorney was Michael Paul at the time.
Yes.
And just quite honestly, it was a less serious case and just wanted to keep the matter moving.
Okay. I didn't know if Attorney Paul stated some excusable reasons for the record. Okay.
Well, the court just wanted the matter moving.
All right. Well, in this case, I would note that Mr. Sonnenberg is seeking residential treatment for substance abuse and mental health. We don't have a report from Koinonia or admission with Ms. Hildy simply because he has not been able to get a Zoom appointment. The jail policy, after talking to Lieutenant Mogen, is that they're overwhelmed with Zoom appearances, so they'll only grant them if there's a chance they may be successful. So what I'm asking the court to do is conditionally lower bond to a $25,000 signature bond from the current $50,000 cash bond, because and the conditions would be that for the reduction would be that the treatment provider or LCO with presumably
the prosecution, and they are not pulling punches. Case building. They're bringing out the big guns, past violent offenses, restraining order violations, and a federal drug case. This isn't just opposition. It's a case building blitz.
On official letterhead to the clerk of courts, proof that Mr. Sonnenberg is admitted to a inpatient treatment facility and would be supervised, and then that condition would not apply until the jail. It would also require the jail to verify that satisfactory transportation arrangements have been made to ensure that he gets there versus just Mr. Sonnenberg, here you go, and that if Mr. Sonnenberg leaves or is discharged from Koinonia or a different treatment center they may find, that his conditions of bond would return and Mr. Sonnenberg would need to return back to the custody of Burnett County on his $50,000 bond. I mean, unless he was were able to miraculously come up with the $50,000 in cash. Would note that Mr. Sonnenberg has been in custody since January 3rd. He's informed me he's not able to, provide any meaningful amount of bond. And when you look at the conditions of bond, it's to ensure appearances. If he's in a treatment facility, they could arrange Zoom or other means to ensure that he appears for court. This also provides protection for the community because, again, Mr. Sonnenberg would be at a residential facility that does have 24/7 supervision. And Mr. Sonnenberg would also be in a position where if he chose to leave it or were discharged, he would have to return promptly to the Burnett County Jail, or else he would be facing a potential additional charge of charges of felony bail jumping. And so we're not asking for Mr. Sonnenberg in these serious charges to just be, off to the races and free with no supervision and no concerns for protection for potential of alcohol or other items. But I do believe that the bond motion provides for the protection of community. Court has to consider, and Mr. Sonnenberg's, potential danger to community is obviously, lower than would be for anyone on a normal basis because, again, he is recovering from multiple gunshot wounds, and without transportation, he's likely to stay where he's at. So, would ask the court to grant the bond modification that would be contingent upon providing the treatment And that would allow the jail has informed me that they would allow Mr. Sundberg to do a Zoom arrange a Zoom with Miss Hildy so that he could get placed in a treatment, which would be, for his own good as a citizen as well. But, they're not going to schedule a hearing if his bond is still at $50,000 and he has no meaningful opportunity to raise that.
All right, thank you. Mr. Schmidt?
After the Dale Brooks case, the legislature
17 and a half years. That's the kind of sentencing that'll make anyone consider skipping town. The prosecutor knows at 10. He's waving that number like a red flag to say this man has motive to run.
to look at something else. When someone's charged with a violent offense, the court can look at other past violent offenses and a criminal history and set needs based upon that for protection of the public. When I look at Mr. Sonnenberg's record, I see something of a pattern of violence in his history. A lot of his early history in the 2004 to 2006 range, it's just DCs. There is one case involving actual injury that was an OWI causing injury in 2005 in Barron County. In 2006, he was first convicted of selling cocaine in Barron County. Read into that case was a substantial battery. 2006 Washburn, DC with another battery read in. And then he had his federal prison case, which was a large crack cocaine conspiracy in the St. Croix tribal lands. He had a 17-and-a-half-year sentence on that. After getting out of prison, he had a Washburn 2021 case with crime damage with burglary dismissed but read in. Another OWI, then Polk County in 2023, a DC with a battery read in, and then our Burnett County, a DC with a battery read in. He has two other open cases right now, both in Polk County, both are DC with repeater. I see that in the recent past, he's again behaving erratically. This case itself involves erratic behavior, charging the police after being at the home of MM in violation of a restraining order. I think the biggest problem I see, though, is the fact that one of the allegations here is just him violating the restraining order, and he's on body cam inside the house he's not supposed to be at. I can't fathom why we would conclude a signature bond or a lower cash bond would have any effect on Mr. Sonnenberg when a restraining order that was only issued in September of last year didn't deter him. I think that there's a real serious risk of death or great bodily harm to MM if the court reduces bond or releases him on a signature bond. I don't think inpatient qualifies as supervision for Mr. Sonnenberg because it won't stop him from leaving or walking away. They're not going to physically restrain him. The danger still exists there. The maximum penalty on this case,
17 and a half years. That's the kind of sentencing that'll make anyone consider skipping town. The prosecutor knows at 10. He's waving that number like a red flag to say this man has motive to run.
17 and a half years just on count one, just like that federal sentence he was sentenced to. I think if anyone knows how terrifying that amount of exposure is, it's Mr. Sonnenberg. He has a lot of reasons to walk away or hide from this case. I think that should give the court pause about likelihood to appear. I think the court should have even greater concern about danger to the public. Thank you.
All right, thank you. Hearing the arguments from both sides and in review of at least the allegations that are stated in the criminal complaint that do rise to at least probable cause, this is a very serious case and the court does need to consider protection of the public and here at least protection of the victim because there is a potential for serious risk of great bodily harm. And as it was pointed out, if a piece of paper, an injunction could not stop Mr. Sonnenberg, there's no guarantee that putting him into an unarmed, unmanned treatment facility would protect the.
And the gavel drop spun stays at $50,000 cash. The court's message is clear. Rehab is great, but public safety comes first, especially when a piece of paper didn't keep the victim safe last time.
Going to deny the request for bond modification and will keep it at $50,000 cash. So let's get another date and time so that we can come back to court and we can see where this matter is going and if we need to set it for trial.
Your Honor, my client's indicated that he wishes to exercise his rights to a speedy trial now that the information has been filed. It's now timely, and the defense has filed the discovery motion. So,
all right. So, Mr. Schmidt, how many days do you think that we may need for a speedy?
It's 2 on the edge of 3. So I would say 3 to be safe. One of the things that's going on is we're waiting to get like medical records of Mr. Sonnenberg. So
and do we need lab?
We might. His blood was sent to the lab. We don't have results yet.
Let's just schedule without lab right now. And hopefully we won't need lab, because if we don't have results, we don't have an analyst, then we know that this is speedy and hopefully they'll be able to accommodate.
Yeah.
All right. I'm going to check while my assistant checks. It may unfortunately fall on an ADA week,
That's fine.
because we have a lot of trials in the next. Must be closer in March. Or our 3-day Benjamin Lamb case is coming off on February 18th through the 20th.
There is over 300 pages of discovery. I don't know if Mr. Keene will be ready for that.
Oh, that's what I was going to say. And also, depending upon getting the view of the discovery, the defense may have a motion to attack count 1 before trial based upon what's in the.
Just letting you know, I had a 3-day that resolved, and I have 3 days open, February 18th through the 20th.
Let me check my calendar to see what I have
to.
to.
For that though. Because I don't know if we'll use the labs at all is the thing, because it's just Mr. Sonnenberg's blood, which we anticipate is going to show alcohol and cocaine.
Right now I have a jury trial in Sawyer on the 20th. That'd be the 3rd day. So, I mean, part of me thinks it resolved in 2, but.
I think there's a good chance we could get it done in 2 if the court wants to do 18 and 19.
I mean, obviously, I prefer some days closer to the
Off record.
90, but
Oh, Mary stepped away. I don't know where she is. We're off record, so you think maybe you could do it in 2?
Yeah, like the relevant body cam is like 5 minutes or less. What I'm uncertain on is I don't know how long MM and RL will testify. I don't know if the blood could possibly be relevant. I don't know that it will be. Otherwise, my total witnesses would only be 1, 2, 3, 4, 5, 6, 7. 7 or 8 witnesses for me.
Well, I could double it up with Jacobowski. I'm not sure if that's likely to go. That is set for a 2-day. I think March 6th and no, that's April 3rd and 4.
What do you think?
Well, they'll upload it to desk today. They can upload it to desk today.
Okay. Well, I would have to cancel some of my other hearings for the 18th and 19th, but I'm sure the other courts would comply with that to get a jury trial in. Because Mr. Sonnenberg is requesting to.
We don't have a head clerk here.
Okay.
Because she's on vacation. I talked to Danny.
She doesn't know about it.
What?
She doesn't know about it.
All right, I will. For now, we are requesting a speedy trial. The court has conferred with deputy clerk as well as assistant to find 2 full days to have a jury trial in this matter, to meet speedy trial. We can do April 3rd and 4th. That works with the calendars of Mr. Keene as well as the court. This will be a number 1 for the court, and the court has another jury trial scheduled for that date and time, which will now be a number 2 because speedies do take precedence.
And here comes a final warning. February 28th is a drop dead date. No deals. Final warning, no amendments. No backpedaling past that point. It's trial or bust. Think Zonenberg's team will blink before then.
And 3rd, April 3rd and 4th. Now let's get a final drop dead date. That means I will accept no other agreement past this date and time. So, Mr. Sonnenberg, it means that if you do not reach an agreement, you do not reach any type of resolution by this date and time, it will go to trial for every single charge unless they are completely dismissed in entirety by the state. All right, let's see where I have you. Let's do Mr. Keene. February 28th at 9:15. February 28th at 9:15.
Works for the defense.
All right. February 28th at 9:15. I will schedule you then. That is the final pretrial. That is the court's, again, drop dead date. I will accept no plea agreement after that date. Nothing. No reduction in any, no amendments or modifications of any charges, no agreements to any sentencings, nothing beyond that date. It will either be after that date and time. If there is a resolution after that date and time, it would be plead to all of the charges as charged and proceed to sentencing or dismissed in entirety. Otherwise, the matter goes to trial. Is that understood?
I don't recall the schedule. Will February 20th then also be the deadline for amending upwards on the information?
Yes.
Okay, thank you.
Well, I mean, technically, that's not what case law says, but
The
case
court
law,
can control. Yeah.
yes, but yes.
Thank you.
Thank you. We are adjourned.
Thank you.